it seems that we have divergent views as to what should my lady do today. What we discern from those heads is that they propose that there is a two-stage inquiry before my lady. The first being whether what we propose to be questions of law are in fact questions of law. And the second being whether we pass the threshold that is otherwise applicable in an application for leave to appeal. And this is to say whether there is no prospects of success on appeal, should my lady agree with us that what we propose to be questions of law are in fact those. We make a different submission. We say there is no two-stage test before you. We make the submission that we don't have to show you that there are reasonable prospects of success on appeal. We say you don't have that jurisdiction. The jurisdiction you have relates only to the question whether what we propose as questions of law is in fact questions of law. But of course we accept that my lady is not bound by the manner in which we framed those questions. My lady may decide to frame them differently. Why do we say that the court doesn't have to consider the inquiry as to whether there are reasonable prospects of success on appeal? The Supreme Court of Appeals has said. Could I hand up two decisions that I will rely on during the course of my address?
Why would you go to that? Mr. Davis, his arguments were submitted, I think, on the 25th of October. But your his argument today, that makes preparations difficult.
But I profusely apologize for that, and in fact, I concede that I should have started there immediately after the application for condemnation. It's not an excuse, my lady. I was not available at all. I was on the bench until last week Friday. I apologize for it profusely. It shouldn't have been like that. That should have been prepared well in advance and placed before you.
Now you want to reveal some documents?
It's two cases, my lady, that are not referred to in the past. The first case that I'm going to implore my lady to take a look on is Director of Public Prosecution's Gauteng Division, Victoria, and KM. That case didn't deal with Section 319. It dealt with Section 311. But it's relevant in the argument that we propose to make because it makes it clear that applications such as 17 before 8 are applications predicated solely upon the Criminal Procedure Act, and that Chapter 5 of the Superior Courts Act 10 of 2013 is inapplicable. And that's why the test relating to the prospects of success on appeal would be found. The relevant passages that I intend for my lady to have regard to is paragraphs 19, 25, 32, 19, 25, 32, 34, 35, 40, and 50. I just placed before my lady what 40 and 50 said. The context of Section 311, please read 319, must be considered. Most other sections of the Criminal Procedure Act which allow for an appeal require applications for appeal. These include 309 1A, 309B 1A.
Which paragraph are you now?
40, 40, yes, 40. The context of Section 311 must be considered, and I've made the submission that my lady should read 319 for 311. Most other sections of the Criminal Procedure Act which allow for an appeal require applications for leave to appeal. And then the learned judge mentions that. These include, he mentions them, and then he says, it is clear that these are appeals regulated in terms of the Criminal Procedure Act. They give the right of appeal and deal with the procedure for the exercise of that right. In all cases, the procedure requires an application for leave to appeal. Now, these are all other cases, but those that are mentioned above. And then he says in paragraph 50, it is of course instructive that unlike other sections in the Criminal Procedure Act, section 311, which is similar to 319 we submit. The case I'm referring to, my lady. This is Director of Public Prosecutions Trafficking versus KM, of the two cases that I handed up. Then 50 says it is of course instructive that unlike other sections in the Criminal Procedure Act, section 311 does not in terms specify that any form of leave to appeal must be obtained. And we say the same applies to 319 of the Criminal Procedure Act. It doesn't specify in terms that an application for leave to appeal must be obtained. And this is where the test that is found in sections 16 and 17 of the Superior Courts Act will be found, which requires that there be prospects of success on appeal for the court to grant leave. But if that is not clear, then it's clarified in the second judgment that I handed up, the judgment of the DPP KwaZulu-Natal versus Ramdas. Now ask my lady to consider paragraphs 23 and 24 of that decision in page 11 of the judgment. The SCA says, before dealing with the merits of whether the court should have reserved these issues as questions of law for consideration by this court, it is necessary to examine what the court considered when deciding this issue in respect of each of the questions sought to be reserved. In addition to determining whether they were questions of law, the court decided that none of them had reasonable prospects of success. This is exactly what our colleague says you should do, and we submit that you should not do. At 24, the SCA then says, however, all that the court had to decide was whether the issues sought to be reserved by the state were questions of law. Full stop. Whether any of the questions sought to be reserved possessed reasonable prospects of success in this court did not constitute part of the inquiry before the court. We submit, my lady, that that is in fact the law. So that the issue before you is not whether there are prospects of success on appeal on the questions that we ask you to reserve. The issue is whether what we ask you to reserve are questions of law. Whether they succeed or not, whether there are reasonable prospects of success or not, that's something that we'll deal with when we come before the Court of Appeal. In fact, that will not even be the test, because then we will be going to that court should you reserve these questions, simply on the basis that you are before the appeal court on the basis of a notice of appeal. So, my lady, so much about what we are about, what you should be doing, and what the law says in this regard. We say these are binding authorities of the Supreme Court of Appeal. We note that our colleague relies on, among others, Basson. But surely the cases that we rely on are very recent in relation to Basson, and we must accept, even if we disagree with the cases that we are referring you to, that the SCA knew that it had earlier decided Basson and it had said certain things in Basson which it doesn't say in its recent jurisprudence, so that it would have turned down whatever it would have said in the earlier cases. The law that applies today is the law as stated in the cases that we just mentioned. Then, you would have seen that in the very notice that we served together with the application for condonation, that we propose 6 questions for reservation by Malaysia. And as I've made the submission earlier, Malaysia is not bound to frame those questions if she agrees with us in the manner that we propose them. But the requirement is that the question must be framed accurately so that there is no doubt as to what the legal point is. And the court will be required to show or to put up the facts upon which the point that it frames is clearly set. Rather, the facts upon which each point is based must be clearly set out. And it must be something that comes from the record. We deal with that in paragraph 13 of the heads of argument that Malaysia received this morning. On any consideration of the respondent's heads of argument, we seem to be in agreement, at least on this point. Now, the first question is whether Malaysia employed the proper approach to be applied in the evaluation of evidence used in a criminal trial. Again, as to what that approach is, we are common cause with the respondents, because we both rely on S versus fundamental, as decided by Justice Nugent, then sitting in 𝐽𝐻𝐿. And we know that that is in fact followed by the Supreme Court of Appeal in various and many other decisions. We say that on any reading of the judgment, it doesn't appear that that Malaysia applied the principles referred to there. Now, as we've made the submission before, we propose that Malaysia frame that question of law on the basis whether the trial court employed the proper approach to be applied in the evaluation of evidence accused in a criminal trial. We say it is not a factual issue.
You say the first question of law is not essential.
It's not a factual, Malaysia, not a factual issue. Because we as the state, we can't appeal on factual issues. We accept that to be the correctly appropriate. Then the next question is whether, in failing to provide in its judgment factual findings consistent with the provisions in Section 146B of the Criminal Procedure Act, the trial court unduly curtailed the right of the state under Section 34 of the Constitution. We seem not to be at the jam with our colleagues for the respondent on this score. We suggest to Malaysia that, as Malaysia would know, the right of the state to appeal in a criminal trial is already curtailed, and the state can only appeal based on questions of law, or those questions of law must be founded or based on factual findings. I was before Malaysia about 2.5 months ago, and the submission I made was that the judgment does not give anyone any factual findings. Malaysia made a judgment in that case. I am today not suggesting that that judgment is wrong. I am merely suggesting to Malaysia that it would be proper to frame that question that we suggest as question number 2. And we, in justifying this, we rely on, among others, the decision of the Constitutional Court in 𝐼𝐻𝐿, as well as the decision of the Constitutional Court in Gqeberha. Those decisions are in footnote 9 and 10 of the heads that we submitted earlier this morning. Again, we submit that that's not a factual issue. It is a question of law. Then question number 3 is whether the trial court...
Any criminal matters that you can refer to? When you refer to sections footnotes 9 and 10, I haven't had the opportunity to read them due to the circumstances. But do you have any criminal matters?
No, I accept that. I accept that, but the provision in Section 146B is a provision in the Criminal Procedure Act. So that the injunction, the statutory injunction there that applies to all judicial officers comes from the Criminal Procedure Act itself. Then, if I may proceed to question number 3, whether the trial court correctly considered the nature of the evidence of the state as being similar fact evidence and thereafter correctly applied the principles applicable to the evaluation of such evidence to prove a modus operandi for the commission of the offences contained in the indictment as amended. We submit that, again, that's a question of law. And reliance there, my lady, on why that is a question of law is through one of the, well, now not so recent decisions of the Supreme Court of Appeal in Pistorius. There, just
You refer to any specific part of Pistorius?
that was in paragraph 36, my lady. To paragraph number 38. And this reference is, my lady, will find in my head from paragraph 27 to paragraph 29. Then, with respect to the balance of the questions of law that we propose, that would be questions 4, 5, and 6. Even in that regard, my lady, we rely on Pistorius, on the very same paragraphs that I've just pointed out to my lady. Ultimately, the submission we make, my lady, is that what we propose to you is not at all factual issues. It is questions of law, and as I've said it, I think 2 times before, my lady is not bound to frame them in the manner in which we propose them. But what is important is to keep to the standard. And secondly, what is important is to realize that prospects of success on appeal have no role to play before you. You don't have jurisdiction to deal with the matter on that basis. The only question really is whether, as the SCA has said, what we have proposed as questions of law is in fact questions of law. Thank you, Malika. Unless you have questions for me, those are my submissions.
I haven't had the opportunity to go through your supplementary exhibit.
Maybe I will take you through the supplementary briefly. Well, just on the question of onus, or on the question of the test, I might feel the ladyship to paragraph 2.5 of my main brief where I quote on the decision in Person. Where the Supreme Court of Appeal held as follows in paragraphs 10 and 11. I quote paragraph 10. This is follows. Wanneer in rechtspraak soos vermeld ontstaan, word die verhoorhof of indien hy sy weier deur die hof in diskresie op aansoek deur die staat daardie rechtspraak voort te behou vir deur die hof. Daardie discretion that either the trial court or the Supreme Court of Appeal exercise. Daardie diskresie sal, soos in die geval van enige ander aansoek vir verlof van kanselleer, slegs ten gunste van die staat uitgeoefen word, indien daar 'n redelike vooruitsig is dat die hof van appel sal bevind dat 'n regsfout inderdaad begaan is. Dit sal egter nie ten gunste van die staat uitgeoefen word indien dit bloot van akademiese belang is nie. Dit sal die geval wees indien geen regshulp aan die staat verleen kan word, indien bevind sou word dat 'n regsfout begaan is nie. So, it's very clear from that judgment and that paragraph, my lady, that it is indeed a requirement that there must be a reasonable prospect of success in the proposed appeal. And that makes sense with due respect. I must concede that the decision referred to by my learned friend, the Director of Public Prosecutions, 𝐬𝐮𝐬𝐜𝐿 versus Ramdas, which was handed up to your ladyship, appears to say something different. If I can take your ladyship to paragraph 23 of that judgment, where the Supreme Court of Appeal says the following: before dealing with the merits of whether the court should have reserved these issues as questions of law for consideration by this court, it is necessary to examine what the court considered when deciding this issue. In respect of each of the questions sought to be reserved, in addition to determining whether they were questions of law, the court decided that none of them had reasonable prospects of success. And in 24, however, all the court of 𝐶𝐿 had to decide was whether the issues sought to be reserved by the state were questions of law. Whether any of the questions sought to be reserved reasonable prospects of success in this court did not constitute part of the inquiry before the court of 𝐶𝐿. As decided by this court in this versus Basson, when a question of law arises, the trial court, or where it refuses to do so, this court has to decide on application by the state whether to reserve a question of law for consideration by this court. When this court considers an application by the state for leave to appeal against a refusal to reserve a question of law by the trial court, as with any other application for leave to appeal, it will only exercise its discretion in favor of the state where there is a reasonable prospect that a mistake of law was made. In addition, there must at least be a reasonable prospect that if the mistake of law had not been made, the accused would have been convicted. So it's arguable that this more recent decision qualifies what was said in the Basson case, my lady. But with due respect, it does not appear that the decision in the later case properly considered what Basson in fact held, because it is quite clear from the paragraph in Basson that I quoted that both the trial court and the Supreme Court of Appeal are required to consider whether there is a reasonable prospect of success on appeal, and not merely whether there are questions of law which ought to be reserved. It seems rather anomalous that the Supreme Court of Appeal is required to consider whether there is a reasonable prospect of success, but that the trial court is not required to apply the same consideration. So the question which your ladyship will have to decide is what the effect of these two apparently conflicting decisions are, and whether in fact the later decision qualifies the decision in Basson. It seems that in the later case, the Supreme Court of Appeal misconstrued what was stated in Basson, because Basson clearly states that the trial court's discretion to grant leave to appeal includes an inquiry whether there is a reasonable prospect of success on appeal. The decision referred to by my learned friend, which deals with Section 311 of the Criminal Procedure Act, doesn't apply to Section 319 if you read that decision carefully. I won't take you through it, but if you read it carefully, it's quite clear that that decision has got no application to section 390. I would submit, my lady, that the later case does not overrule, the later Supreme Court of Appeal case does not in fact overrule Basson, and that it is based on a misreading of Basson, and in the circumstances that the earlier decision, the decision in Basson, would be the applicable one, and that your ladyship is required to follow that decision. That would be my submission on the question of the test. Lady, I will now turn to deal with the merits of the application itself. And I will take your ladyship, or perhaps I should take your ladyship to paragraph 3 of my supplementary, is where I deal with the question whether there is a reasonable prospect of success in the proposed appeal on the questions of law posed by the applicant. There I refer to the decision in Basson, and I can take you to 3.4. The state's right of appeal is therefore narrowly confined to instances of clear legal misdirection that, if corrected, will have led to a conviction. Section 390 does not authorize the disguised appeal against factual findings or an attempt to relitigate issues of credibility in evidential way. Even if it were assumed for argument's sake that one or more of the issues raised by the state could be characterized as questions of law, the application must nevertheless fail, because none of the alleged errors, if corrected, could have affected the outcome of the trial. The trial court found, your ladyship found, that the complainants were not incredible witnesses, but that the evidence was unsatisfactory in material respects, that the respondents' exculpatory versions were not false, and that the state failed to prove his case beyond reasonable doubt. These findings are factual in nature and dispositive of the matter. It is common cause that the respondents' exculpatory versions were not disputed during cross-examination. The prosecutor failed to challenge the core denials or to put the essential elements of the state's case to any of the respondents. Their evidence thus stood uncontroverted. In law, unchallenged testimony must be accepted as reasonably possibly true. And that is precisely the finding that your ladyship made, and you complied with the approach, or followed the approach set out in Van der Meijden and the 𝐶𝐵𝐻𝐵𝐻 cases. Once the trial court accepted that the respondents' versions were reasonably possibly true, acquittal became inevitable. The court was precluded, both as a matter of law and logic, from making factual findings in favor of the state on any contested issue. The onus remained on the prosecution to prove guilt beyond a reasonable doubt, and that burden was not discharged. Your ladyship also found that the respondents to be credible witnesses. That finding, being one of demeanor and impression, is a quintessential factual determination falling within the exclusive province of the trial court. It is not appealable under section 319. In these circumstances, even if every alleged legal error advanced by the state were assumed to be correct, no reasonable prospect exists that the outcome would have been any different. The respondents' credible and unchallenged evidence required the acquittal. The alleged errors are therefore academic and cannot justify the reservation of any question of law. The inevitable conclusion is that this application serves no practical purpose. The findings of credibility and the acceptance of the respondents' versions as reasonably possibly true rendered the acquittals final in law. No alleged legal misdirection could have altered that result. The applicants have neither alleged nor demonstrated there exists any reasonable prospect that the Supreme Court of Appeal would find that a legal error occurred and that but for such error the respondents would have been convicted. The heads of argument proceed on the contrary premise that the issue of prospects is irrelevant. In my respectful submission today, that contention is wrong and contrary to the decisions that are referred to in paragraph 3.1. The failure to address the requirement of reasonable prospect is dispositive of the application. It deprives the court of any factual or legal basis on which to exercise its discretion under section 319 in the applicant's favor. And absent any such showing, the application is academic and must be dismissed. I'll now deal with the arguments in relation to the questions of law proposed by the state. Paragraph 4.1 of mine. The applicants contend that your ladyship failed to apply the proper approach to the evaluation of evidence as set out in this versus and 𝐬𝐮𝐬𝐜𝐫𝐢𝐻𝐿𝐼, and that this alleged failure gives rise to a question of law. They rely on the victim of 𝐬𝐮𝐬𝐜𝐫𝐢𝐻𝐿𝐼 that the state must prove beyond the reasonable doubt while the accused is entitled to acquittal if his version is reasonably possibly true. In my respectful submission, this argument is misconceived. Your ladyship expressly and correctly applied the very principles articulated in 𝐬𝐻𝐫𝐷𝐻𝐿𝐼. Your ladyship weighed the evidence holistically, considered both the state and the defense versions, and acquitted only after finding that the state did not discharge its onus. The applicants, and this is important, the applicants have not identified any passage in your ladyship's judgment reflecting a departure from that text. It's been argued in the air before you that you failed to follow the approach set out in that case. On a proper reading of the judgment, you in fact followed the correct approach. So the argument in that regard is unsupported by the record, and my learned friend hasn't referred your ladyship to any part of the record which shows that you failed to follow the correct approach in the analysis of the evidence. Yes, ma'am.
Failure to cross-examine.
Yes, ma'am.
Apparently that finding of mine isn't considered to be an error involved.
No, ma'am.
And failure to cross-examine formed a component of every one of these considerations.
Indeed, ma'am. It goes to the root of your ladyship's ultimate finding, the failure to cross-examine.
And it reflects in each of these questions of law that must be resolved.
Yes, ma'am. That is my submission, and that is one of the bases on which this application is unfounded, with due respect. There is no attack on that finding of law. That was a finding of law that your ladyship made. You found that in terms of the authority which is cited in your judgment, that the failure to cross-examination on a particular aspect has a certain legal consequence, namely that the evidence, the unchallenged evidence, cannot then be rejected as false if it's not disputed. The accused is entitled to assume that it is accepted if it's not disputed. That was your ladyship's finding in terms of the authorities. And that finding has not been challenged. There's no application for the reservation of a question of law relating to that legal finding. That is the effect of the failure to cross-examine. So, for argument's sake, it must be accepted that your ladyship's finding on the law in that regard was correct. And that has certain consequences, which I've already made submissions in relation to. Ultimately, even if all the complainants were satisfactory witnesses, even if they corroborated each other in material respects, the fact that the state's version was not put to the accused, and the fact that the accused 𝐿𝐻𝐫𝐷𝐻𝐿𝐼 version was not disputed, would have been dispositive, and your ladyship would have been constrained to find that their versions are reasonably possibly true. That is why this entire application is entirely academic. It goes to all of the questions of laws posed by my learned friends in the application. paragraph 5 of the relationship judgment, you stated that although aspects of the complainant's evidence were unsatisfactory, you could not find it incredible. In other words, you accepted that for the purposes of your judgment, that they gave credible evidence. By saying that you could not find that their evidence was incredible, you found that their evidence was credible. So you made a finding with due respect. And then you went on to find that equally you could not find that the respondent's evidence failed to be rejected as false, particularly because it had not been placed in genuine dispute in cross-examination. You held that the respondent's version were not so improbable that they could not reasonably possibly be true. These findings, Malady, with respect, reflect a textbook application of the Van der Weyden test. You did not weigh the probabilities of the two versions against each other. And you asked the correct question, whether the state had proved its case beyond a reasonable doubt. And the answer on the record was plainly no. And the applicant's argument attempts to recast the trial court's factual evaluation as a misdirection in law. It is in essence a complaint that the court should have drawn different inferences from the evidence. And that is a factual dispute, not a question of law. The Supreme Court of Appeal has repeatedly cautioned that dissatisfaction with the trial court's evaluation of the evidence or assessment of credibility cannot be discussed as a legal question. Of my estimate is, there is no allegation that your ladyship applied an incorrect onus, reversed the burden of proof, or adopted the wrong standard. The suggestion that the court did not apply the proper approach is entirely unsubstantiated. The applicants do not point to any specific misstatement of law, erroneous principle, or passage in the judgment that would sustain such a claim. This is entirely an argument in the air, made without any reference to your ladyship's judgment, but to what your ladyship actually says in your ladyship's judgment. Even if, contrary to fact, your ladyship had misapplied the Van der Weyden test, the respondent's unchallenged exculpatory evidence would still have compelled acquittal, and the alleged error would therefore be immaterial to the outcome. It could not constitute a proper question of law under section 390. The complaint thus fails both limbs of the Basham test. It discloses no genuine legal error, and it offers no reasonable prospect that correction of any supposed error could have led to conviction. In my respectful submission, the judgment is in fact a model of adherence to the correct approach. It demonstrates awareness of the evidential burden, the role of cross-examination, the relationship between credibility, reliability, and the ultimate question of proof beyond a reasonable doubt. Your ladyship expressly recognized that the state's failure to test the respondent's version through cross-examination left the evidential foundation fatally incomplete. My lady, the first proposed question of law raises no genuine legal issue. Your ladyship applied the correct legal test, made reasoned factual findings, and acquitted in accordance with settled authority. The applicant's complaint is one of fact, not law, and a question forced to be dismissed. Then, in relation to the second question of law, my lady, it is contended by the state that the trial court failed to provide factual findings consistent with section 146B of the Criminal Procedure Act, and that such failure could curtail their constitutional right under section 34 of the Constitution to have the matter fairly and properly adjudicated. They further argue that the absence of detailed factual findings limited the state's ability to formulate questions of law under section 390. With due respect, my lady, this contention is entirely baseless. Your Ladyship's judgment contains both factual findings and conclusions of law as required by Section 146B. Your Ladyship expressly found that although there were unsatisfactory aspects in the complainant's evidence, your Ladyship could not find them incredible, that the accused versions were not false, and that because those versions were not properly challenged in cross-examination, the state had failed to prove its case beyond. These constitute clear factual findings, namely, A, the complainant's evidence, while not incredible, was insufficient to sustain a conviction. B, the respondent's evidence was credible and reasonably possibly true. And C, the state did not discharge its onus. These are essential factual premises on which the verdict rests. Section 146B requires a reasoned judgment containing findings of fact and conclusions of law. It does not require a judge to deal with every witness or every factual dispute in detail. Sufficiency, not prolixity, is the standard. The trial court's reason, your Ladyship's reasons, fully explain the evidential basis of the triples and therefore comply with the section. The applicant's complaint confuses brevity with deficiency. The fact that the judgment is concise does not mean that factual findings are absent. The Supreme Court of Appeal has repeatedly held that a judgment satisfied Section 146B provided it discloses the reason path leading to the verdict. The judgment in this case claims that the respondent's versions were reasonably possibly true. He concluded from making contrary factual findings in support of the conviction, and this is a point that my learned friends appear to miss, with due respect. Or if it's possibly true, you were precluded from making contrary findings that the failure to take account of certain evidence amounts to an absence of appreciation of relevant material which constitutes a legal error. Once again, my lady, this contention is factually incorrect and legally unfounded. Your ladyship's judgment demonstrate that your lady is fully aware of the nature of the evidence and that you consider whether it could lawfully be used to infer a modus operandi or pattern of offending. Having done so, your ladyship concluded correctly that reliance on such evidence would be constitutionally impermissible in the light of the fair trial rights of the accused. In paragraphs 56 to 58 of the judgment, your ladyship referred to Luna and 𝐶𝐿, acknowledging that similar fact evidence may, in limited circumstances, be admissible to prove identity or a systematic course of conduct. Your ladyship then distinguished the present case, finding that the complainants had been in contact with one another, had discussed the case prior to the laying of charges, and had been part of a WhatsApp group in which the lead complainant coordinated communication with the prosecutor. On that factual foundation, your ladyship found that the apparent similarities between the complainant's accounts were unreliable and constitutionally tainted. You accordingly held that the similar fact evidence cannot be taken into account in the instant matter in the light of the fair trial principle, as we referred to it as. This was not a failure to appreciate relevant evidence, it was a conscious and reasoned decision to exclude certain inferences because their admission would compromise the fairness of the trial. The decision was grounded in section 35(3) of the Constitution and constitutes a value-based judgment within the court's discretion, not a misdirection of law. The applicant's reliance on Pastores is misplaced. In that case, the Supreme Court of Appeal intervened because the trial court had entirely failed to take account of material evidence bearing on intention. Here, by contrast, the trial court, the ladyship, demonstrably considered all the evidence and made an informed decision as to its admissibility and weight. That is the opposite of an absence of appreciation as contemplated in Pastores. The applicant's argument confuses the concepts of admissibility, relevance, and weight. The ladyship did not rule the evidence inadmissible. You simply accorded it no probative value in the light of the demonstrated collusion and contamination among complainants. That assessment is factual in nature and incapable of giving rise to a question of law. Whether alleged similarities between different complainants' accounts establish a consistent modus operandi is an inferential question of fact, not law. And the ladyship's conclusion that the pattern was unreliable and constitutionally compromised lies squarely within its evaluated discretion. The applicants have not identified any specific misstatement of the legal principles governing similar fact evidence, nor have they shown that the wrong test was applied. The record reveals no misunderstanding of the doctrine or the authorities on which it rests. The complaint is therefore unfounded both in fact and in law, even if it were assumed for argument's sake that the court erred in its assessment of the probative value of the alleged similar fact evidence. Such an error would be factual and immaterial. The respondents' versions were found to be credible and reasonably possibly true. No inference from pattern or modus operandi could have displaced that finding or altered the outcome of the trial. The applicants have also failed to demonstrate any reasonable prospect that the Supreme Court of Appeal could, on the same record, reach a different result. The evidence of alleged similarity was not merely weak, it was constitutionally tainted. Its revival and appeal would therefore be impermissible. The third proposed question of law fails to meet any of the jurisdictional requirements of section 319. It does not raise a genuine legal issue. It rests on a factual mischaracterization of the judgment, and it could not, even if upheld, have produced a conviction. This question is academic and must be dismissed. Now, go to spoken paragraph 7 already. These are my arguments in response to the applicant's arguments on the fourth question of law. The applicants contend that the trial court erred in finding that the evidence of prosecutorial misconduct relevant without first determining that the conduct amounted to a violation of the respondent's fair trial rights under section 35(3) of the Constitution. They submit that absent such a constitutional finding, the alleged misconduct should have been disregarded as irrelevant. So what they are suggesting is that unless you had found that the accused's fair trial rights had in fact been violated by the misconduct, you were required to disregard the misconduct in making the findings in which you did in this matter. That is the essence of that argument. And if my memory serves me correctly, you specifically raised this issue with counsel for the state during argument in relation to conviction before your ladyship delivered your ladyship's judgment in relation to the merits of the case against the accused. This issue was addressed, and counsel for the state conceded that you are in fact entitled to take the misconduct into account.
But it is something that can be put into the state.
Yes, but if my memory serves me correctly, you raised that issue. It was considered that you are entitled to do so. Now a different argument is raised. The argument is now that because you didn't find that the misconduct resulted in an unfair trial, you're not entitled to have regard to the misconduct in evaluating the cogency of the evidence. With due respect, that argument is in any event you'll concede with due respect. It's obviously something that you are obliged to take into account. The impact of the misconduct of the prosecutor on the cogency of the evidence that was placed before you. And you in fact found that you could not determine what the effect of that misconduct was on the evidence of the complainants. If I might continue at 7.2 of my head. In my submission, this contention is misconceived. The relevance of evidence in criminal proceedings does not depend on whether it reaches the threshold of a constitutional breach. Relevance is a question of logic and materiality, not constitutionality. Evidence is relevant if it tends to prove or disprove a fact in issue, including the credibility and reliability of witnesses and the integrity of the prosecution's case. The applicant has not referred to any authority in support of the argument that is made in this regard on behalf of the state. Your ladyship was entitled, indeed obliged, to consider evidence of prosecutorial act in assessing the reliability of the state's case. That evidence bore directly on the conduct of the prosecutor, the credibility of witnesses, and the fairness of the process by which the state's case was defended. Its relevance arose as a matter of ordinary evidentiary principle, quite apart from any constitutional conclusion. Your ladyship's judgment demonstrates that you did not treat prosecutorial misconduct of acquittal. Considered it as one factor within the broader evidential mosaic, bearing on the credibility and reliability of the state's witnesses. You did not make any finding of constitutional unfairness, nor were you required to do so in order to weigh the significance of the misconduct. The applicant's argument confuses two distinct inquiries, the evidential and the constitutional. Evidence of misconduct is admissible and relevant to credibility, reliability, and procedural integrity, even where it falls short of establishing a constitutional breach. A constitutional finding becomes necessary only where such misconduct renders the trial itself unfair, not where it merely affects the weight of the state's evidence. Your ladyship's approach is entirely consistent with authority. In 𝐬𝐮𝐬𝐜𝐿𝐫𝐢𝐻, the Supreme Court of Appeal recognized that the conduct of prosecutors and investigators may properly influence the evaluation of evidence and credibility of witnesses. Nothing in law requires a prior constitutional declaration before such conduct may be taken into account. The applicant's premise would be that the trial court must ignore relationship's consideration of prosecutorial misconduct was also compelled by the fact of the case. The special entries in the record established by the lead prosecutor to influence witnesses, the withholding of material statements, and improper contact with complainants. These matters bore directly on the credibility of the state's case and had to be evaluated as part of the evidential matrix. The applicants have not identified any misstatement of law on relevance or any improper exclusion or admission of evidence. Their complaint is instead that Her Ladyship attached weight to evidence which the state preferred to discount. That is a factual disagreement without evidential weight, not a question of law within the meaning of section 319 of the Criminal Procedure Act. Whether Your Ladyship drew the appropriate inferences from the evidence of prosecutorial misconduct is an issue of fact. Your Ladyship's judgment reveals a rational and coherent reasoning process. The misconduct diminished the reliability of the state's witnesses and contribute to reasonable doubt about the respondent's guilt. Would not have altered their outcome. The respondent's versions were credible, unchallenged, and reasonably possibly true. The presence or absence of the misconduct evidence would not have changed reference to the record. The submission exists that any correction of law could lead to conviction. Those are my submissions. Thank you.
Yes, Mr. Gqeberha.
Thank you, Madam. But what you've heard and what you've been treated to here largely by the respondents is simple, a demonstration that the points of law, the questions of law that we propose to you, one, are bad. But that is something different to they not being questions of law. Two, what you've been treated to is that, in fact, even better they odds of success on appeal. I've demonstrated to my lady that that is not the test before you. The SCA has stated what the test is. What we've also heard is that it seems that the SCA did not properly consider Basson in the Ramdas case. It's a very difficult submission to contend with because in paragraph 24 of that judgment, the SCA in fact refers to Basson. So it's not only a question of, as I made the submission earlier, that we must accept that the SA was aware that it had earlier decided Basson. In fact, it specifically makes reference to Basson. In the same judgment where it says, all that you have to do is to contend whether these are questions of law or not. If we were in mind as the respondents, we would accept that we would have heard court and point you to deficiencies that we believe are there. But the SA says no, you have to look and accept or disagree with the status questions of law or not. That's what the law says. Now, this is why you have had to listen for almost 45 minutes to what was placed before you. It's because our colleague goes to the question of what. Then you were told that, in fact, the right to a fair trial does not extend to the state, and you asked for an authority to that effect. None was placed before you. It's unsurprising that none was placed before you because none exists. In fact, the Constitutional Court on this score, in 2008, in the State versus Shaikh matter, the reference is 2008, volume 2, SA, page 208, in bracket CC. The relevant paragraph is 43. 208, 2 SA, 208 in brackets CC. The paragraph is paragraph 43. The Constitutional Court made it clear that the right to a fair trial, in fact, extends to the state because the state represents the public. It said the following, if I may read from my reading.
it would be convenient to restate the principles employed by a court in determining the fairness of a trial. The applicants stress that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsections 35(3)(a) to (o) of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street conferring an unlimited right to an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and horror of a crime. So we submit, my lady, that the Constitutional Court has answered the question that you put to our colleague. The right to a fair trial does extend to the state. Then there was a debate between the court and our colleague about whether the failure to cross-examine doesn't cut across all the proposed questions of law. We respectfully disagree with the proposition that the court put to our colleague. May I just, perhaps for argument's sake, do this? The first proposed question of law is whether my lady properly applied the principles applicable to the evaluation of evidence in a criminal trial. That, with respect, has nothing to do with cross-examination. It has everything to do.
What it has to do is with the evaluation of the accused's evidence.
With respect, my lady, it has everything to do with the evaluation of the totality of evidence.
The totality of the
evidence led, yes.
Which includes that of the accused.
I accept that. It includes that of the accused. But it would include the question whether there was proper cross-examination or not. But the issue at stake is the approach employed by the court. That's the question that we're proposing. The approach employed by the court. Again, if I may take my lady to the question of the prosecutorial misconduct, for instance, which concerned, as I understand it from the record, Mr. Gqeberha forming a WhatsApp group and talking with the complainants, all of them at the same time, and potentially influencing them one way or the other. That, again, has nothing to do with whether cross-examination infests all the proposed questions of law. It has everything to do with the question as is proposed. If I may read it for the court. Whether the trial court correctly considered the lack of relevance of the evidence of prosecutorial misconduct in the absence of finding that same amounted to a denial of the fair trial of the accused. But again, it goes to what the court did, or whether the court did what it ought to have done. It has nothing to do with whether cross-examination was properly done or not. And in fact, on this question, the bull point is whether that prosecutorial misconduct was treated the way it ought to have been by the court. So,
and you say that it should have been ignored completely.
That's not the submission. I'm not making that submission. But
now, what submission are you making?
I'm going to try to run away.
Just what submission are you taking?
I'm going to try to not get into the merits of it because of the submission I made earlier, that the merits are with respect not before you. The submission we are making is that there is a question of law which we submit that this court should properly make to the Supreme Court of Appeal. And that question is whether this court correctly considered the lack of relevance of the evidence of prosecutorial misconduct in the absence of a finding by the same court that which it said is prosecutorial misconduct amounted to a denial of the fair trial rights of the accused. So that's the submission that we're making before my
actually, what you are saying, am I correct, that I shouldn't take the prosecutorial misconduct into consideration, absence of finding of an unfair trial?
That's the submission. Or if you do, to what extent, in circumstances where you did not make a finding that this tainted the trial itself. But again, the submission I'm making it in the context of the debate between the court and Mr. 𝐬𝐮𝐬𝐫𝐢𝐛𝐬𝐜, and the context of that conversation was, or of that debate was, that the failure to cross-examine appears to cut across all these questions of law, and the submission we make with respect is that that is not so. And to understand that that is not so, one merely has to look at the proposed questions of law themselves. So, maybe in closing, may I just say that it seems to us we submit that the main issue here is that the respondents have simply failed to come to terms with the fact that 16 years post the Supreme Court of Appeal handing down the judgment in Basson, it then changed the test. And that is clear from the decision that it handed down in 2019, the Ramdas decision. Now, it doesn't matter whether we like that test or not. It's neither here nor there. It has to be applied. That's the submission that we made. Those are our submissions, Malika, unless you have questions for me.
But you can just reply on one point. Well, if I understand my learned friend for the state, what he has submitted to you is that as long as a valid question of law is stated, then you must grant the application, whether or not there was a misdirection on that question of law. He says you can't consider that. You must, as long as a proper stated in the application, you must grant it, irrespective of whether it is borne out by the record. That cannot be the law. That is not the law in our respective solution. Those are my solutions.
May I reply to that with your leave, Maliki? I'll ask Maliki to consider paragraph 23 of the Ramdas decision. I didn't make the submissions that Mr. 𝐬𝐻𝐫𝐞𝐿 attributes to me. You've got to look at the record, because each question of law has to be founded on the facts. Now, surely you've got to look at the record. You can't just pick them in the air. So that's not the submission that I've made. Paragraph 23 of the Ramdas decision provides guidance with respect. Thank you.
The judgment is reserved.
That's a pleasure for the court.